Good afternoon. Senate Rehab and Social Services will start in 1 minute. I will ask committee members to please take their chairs. Rehab and Social Services will now come to order, and I will ask the clerk to call the roll. I don't know where my clerk went.
Test, 1, 2, 3. Testing, 1, 2, 3. Test.
I've heard from three different groups of people who said they couldn't hear.
Where are they?
In Northern Virginia and in Richmond.
Okay.
Okay, well, once we start again.
Madam Chair, we're good to go.
Okay, thank you. It is important. We are conducting our business in the public sector and for the public, so it's important that we be heard. Senator Boysko, did you want to present the amendment to your bill? It's a line amendment, and this would be to Senate Bill 5017.
Thank you, Madam Chair. I would ask the clerk to read the amendment if possible. If not, I can read.
Madam Chair, so we have a series of 3 line amendments here, just so in case anybody wants to follow along, I'm going to go ahead and
Will the
offer
line
this.
amendments be available on the screen?
They should momentarily, but you have to access them through LIS.
Okay. All right, so for the general public, you'd have to access the amendments through LIS, but go ahead, clerk, and please read the line amendments.
Okay. Madam Chair, the first line amendment is on line 37. After Commonwealth period, strike the remainder of line 37 and through include on line 38. Insert, for the purposes of subsection B of section 53.1-68 and sections 53.1-69, 69.1, 70, and 127, local correctional facility also includes. The second line amendment is on line 40 after A, insert contract or, and the third is on line 40 after agency, insert or contractor.
Thank you. May I have a motion to accept those amendments?
So moved.
Second. All those in favor, please signify by saying aye.
Aye.
Okay, the bill as amended is before us. Senator Boysko, would you please describe your bill?
Thank you, Madam Chair. This bill will allow the Commonwealth to inspect the local corrections facilities being used to detain immigrants. I've been working with the Legal Aid Justice Center and have heard from advocates in the legal community and in Secretary Moran's office regarding the need to narrow the scope of the bill, thus the amendment. The sections of the code provide for a minimum sanitation standards and allow for an unannounced inspection, allow the State Board of Local and Regional Jails to prohibit confinement and require transfer of prisoners in a substandard facility, allow the board to review the death of an inmate, provide the circuit courts with the authority to enforce the board's orders, and allow for access to the interior of a facility by members of the local governing bodies, the Department of Correction staff, and the state and local health department staff. As you know, there is rampant COVID-19 infection at the Farmville facility. In fact, 75% of the detainees have tested positive. No longer will we stand by while our neighbors are detained in facilities that threaten their health, as we have seen, even their lives. And I include the employees who work at those facilities who are putting themselves in harm's way. The Immigration Centers of America, which manages the facilities, refused to allow the Virginia Department of Health to help with the testing. Many people, including our federal legislators and Governor Northam, have asked the federal government to allow the CDC to step in, and it took a lawsuit to bring the federal court to get federal oversight. We are now 5 or 6 months into this pandemic. These facilities have demonstrated that they are not able to maintain basic hygiene, social distancing, and use of personal protective gear. These facilities have caused harms to the detainees, to the staff, and to the communities where they are located, and to which their staffs return to work every day. It is inhumane, and to allow this is reasonable. I ask that my colleagues support the bill and pass it on to the Senate floor. Thank you, Madam.
Thank you, Senator Boysko. We have two speakers who would like to be heard on this bill. One is Simon Sandovola Motionberg. I will ask the clerk to allow Simon to come into the chat box.
If the presenter would unmute their mic.
Thank you, Madam Chair. My colleague Luis Oyola is going to address a little bit the situation that brought us to the point where we need this bill. I want to speak specifically to one of the questions we've received about this, which is with regards to whether federal law permits it. The answer is clearly yes, pursuant to the United States v. California case from the Ninth Circuit, which the U.S. Supreme Court just denied review on 2 months ago. So federal law clearly holds that a state does have the power to regulate detention facilities within that state that are being used to hold ICE detainees, provided that those regulations are no stricter than the regulations on a state correctional facility or a local correctional facility within the state. So that's exactly what this bill does. It doesn't create a new set of standards for the detention facilities that are being used to hold ICE inmates. Rather, it takes the existing health and sanitation standards and gives the state government the power, or rather clarifies that the state government has the power to enforce those standards vis-a-vis the facilities that are entirely contracted to the federal government. Now, it's important to note that the two facilities currently existing in Virginia, which are the Farmville facility and the Caroline County facility, are both constituted under Virginia law as local correctional facilities. They are not facilities that are directly operated by the federal government. This bill would not, were the federal government to open such a facility, this bill would not cover such a facility because, frankly, the federal preemption issues are a lot trickier there. This only covers local correctional facilities, but it clarifies that the health and sanitation regulations and the health and sanitation enforcement regime are apply to those facilities as well. So I'm happy to answer any questions that the committee may have with regards to the bill, with regards to its permissibility under federal law, et cetera.
Thank you very much. I'm going to hear from the second speaker. If we have questions, we'll address them to staff or we'll call you back.
Thank you very much.
Appreciate your remarks. So, thank you, Mr. Sandovola Motionberg. Luisa Oyola is waiting to speak. I would ask the clerk to allow him into the chat box.
Hello, good afternoon, members of the committee. My name is Luis Oyola. I am a community organizer with Legal Aid Justice Center and local committee chairperson for Virginia Coalition for Immigrant Rights, or VIS. Am I good now?
We can hear you, so please go ahead and share your thoughts with us.
Okay, thank you. I'm speaking in support of Boysko's bill, SB 5017, so the Commonwealth can have clear legal mechanisms to provide oversight of local detention facilities contracted to third parties, such as the detention centers in Caroline County and Farmville. LAJC and Vasir sent a letter early on in the pandemic sent letters to the administration early on in the pandemic before a single positive case happened, requesting the governor to order an inspection of the detention centers in anticipation and recognition that these centers were prone to a large outbreak, in part due to the large amount of transfers, as is the nature of ICE detention. After LAJC and Vasir's respective letters, as well as multiple email and phone call campaigns from concerned residents, the general takeaway from the Commonwealth was that they did not have the jurisdiction over these facilities because they were dedicated to ICE detention. 4 months later, and ICA Farmville has had such a massive outbreak that they had 75% positive rate for inmates, dozens of staff testing positive, and one very unfortunate death earlier this month with the passing of James Hill, as well as a few cases in Caroline County Detention Center. I don't want to count them out. At this point, ICA Farmville is national news. And the bottom line is that we urge you to take these events in mind and expand the definition of local jails to include these facilities so the state has clearer mechanisms to intervene without waiting for such terrible outcomes. Thank you for your time.
Thank you, Mr. Oyola. Okay, committee, the bill is before us. Do you have any questions, comments? Or do you
Madam
have
Chair.
preferred action? Senator Reeves?
Madam Chair, I would just ask what the current status is of the detainees in those facilities with regard to COVID and the numbers and where they are now, and has that remedied itself, or what's the status of them?
You would be directing that to our general counsel?
General counsel or the patron of the bill?
Senator Boysko, do you want to respond?
Thank you, Madam Chair. My understanding is that this morning there was an announcement that there was they did allow the inspectors to go in. However, we've had to really fight hard to get that, and I believe that changing the definition to make this a local correctional facility gives us more opportunity to care for our people who are working in those, who are living in that community and not having to put themselves at harm without having to fight a federal lawsuit.
Okay, thank you. Are there other questions from committee members? Okay, hearing none, we operate by motion.
Madam Chair.
Okay, who got to me first? There is a motion to report by Senator Mason. Is there a second? Is there a second by Senator Servell? Or no, Spruill. Second by Senator Spruill.
Madam Chair, I actually had a question for the patron.
Senator DeStef.
Madam Chair, if I may question the patron real quick.
Go ahead.
I believe one of the questions Senator Reeves asked was, how many cases have they had there, and what's the status of those cases today? So an example for that would be, well, they had 100 cases, and there's one active case today. I think that's a question he was trying to ask, and I was hoping to get that answer before we proceeded forward to a vote, specifically on the facility that we're talking about here. Thank you.
Madam Chair, certainly.
Senator Boysko.
I would ask our either Simon or Luis if they have the updated numbers as of today. I want to make sure that I give the most current number. Thank you. If they're still with us, hopefully they are.
Madam Chair, if I may explain myself on why I'm specifically asking that question.
Senator DeStef.
Madam Chair, what we've found is there's a lot of folks who come up asymptomatic, so they'll show that they've had COVID, but they don't actively have it. And as a matter of fact, we're harvesting plasma. We're having them donate plasma with the antibodies, and we're using those in the hospitals today. But with that said, when we say 75% of a facility has COVID, I'd like to know, is that active cases, or 75% tested positive, or we tested 30 people 5 times at a facility, and there's only 100 people in the facility, but those 30 people that we tested came up positive 5, 6, 3, 4 times each. So I'm just trying to get a better feeling for the numbers and the statistics we're using when we quote 75% of. And if you remember, there was a commercial, 4 out of 5 dentists approved. And when they asked, how many dentists did you really have in the full survey? Well, 4 out of 5.
One of our experts who was a speaker would like to respond to the question I do want to note, though, that this is just not COVID-related. This change would be going forward. Okay, Mr. Sandovola, Motionberg.
Thank you for the question. As of today, according to ICE's statistics, which you can find on ice.gov/coronavirus, there are 247 cases positive. The current facility census is a little under 300. So that's still about 75% of the population. Many people have been hospitalized, including one 72-year-old Canadian who died of this disease. There are so many who are very sick that they ran out of isolation rooms in the facility, and so they're engaged in a practice called cohorting, where they basically stick all the sick people together in a dorm. The horror stories we've heard from clients within the facility really can't be overstated. And without this bill, the governor, the health department, the Department of Corrections were left essentially knocking on the door and asking voluntary permission of the facility management. Can we please come in? The governor offered, long before ICE came in and tested everyone, the governor offered to test every single detainee and staff member at the facility. And the facility essentially just ignored that request. And so that's why this is urgently necessary and continues to be necessary.
Madam Chair, while we
Okay,
have the
colleagues,
speaker
there's a
on,
motion.
if I may.
There is a motion before us. It's been seconded. We also have to add to that motion that this bill will be re-referred to finance. So if the maker and the seconder are amenable to amending their motion, I would like to hear that. Thank you. Final question, Senator DeSteffe?
Madam Chair, thank you. My final question was how many active cases are in the facility? And then secondly, what's the cost to the facility to have to implement what we're putting in the bill?
I don't know if our expert speaker or a staff person can respond to that, but that is a question we can perhaps provide an answer to you at a later date.
The number of active cases right now is 247, according to ice.gov/coronavirus, which you can look at yourself. With regards to the cost of the facility, I don't know that could be calculated with precision at this time because, essentially what this is taking the very same health and safety standards that every single local jail in the Commonwealth has to comply with, and also applying it to those facilities as well. And so, to the extent that they're falling short, obviously they'll have to take measures to remediate it. If they're currently up to snuff, if they're already meeting the very standards, then it won't cost them anything at all, of course. But that would be a cost directly to the facility, not to the Commonwealth of Virginia.
Okay, a motion to report and re-refer this bill to finance has been made and seconded. I will ask the clerk to call the roll.
Senator Hanger.
I was having computer difficulties. I will abstain.
Senator Locke. Senator McDougal.
No.
Senator Reeves. No. Senator Chafin. Senator Cosgrove. Senator Serval. Senator DeSteffe.
No.
Senator McPike.
Aye.
Senator Spruill. Aye. Senator Mason.
Aye.
Senator Boysko.
Aye.
Senator Morrissey. Aye. Senator Kiggins.
No.
Senator Favola.
Aye.
Eight ayes, 6 nays, 1 abstention.
Thank you. Next item on our agenda, Senate Bill 5018, the conditional release of geriatric, terminally ill, or permanently physically disabled prisoners. Our patron is Senator Bell. We do have 2 speakers. Senator Bell, I don't see a note about any amendments. Is your bill ready to be presented?
Madam Chair, the bill is ready to go as is. If you'd like me to go ahead and proceed.
Yes, please present your bill.
Thank you. First, I'll say this is verbatim, exactly the same bill that was heard by this committee in the 2020 session. As a refresher, it passed the committee 9-6, and it passed the floor vote 23-15. What this bill does is it would give a mechanism for Virginia Parole Board to consider for release offenders who are permanently incapacitated, terminally ill, they pose no threat to public safety. These people we're talking about are 80% of them are bedridden 100% of the time. So these are folks who generally can't move much. They've been diagnosed with a terminal, they have a terminal diagnosis, 12 months or less is the life expectancy. This bill would allow the Parole Board to review additional cases, consider those offenders who do not pose a threat and whose health care costs due to their condition pose a significant financial burden to the Commonwealth. To be specific, the estimate on this is approximately $58 million of savings to the Commonwealth. If you look at the health care costs providing for terminally ill patients behind bars, it's excruciatingly difficult sometimes to provide care, and it's very costly. Right now, on the background, currently terminally ill offenders have no mechanism to be considered for release through the Parole Board unless they are over 60, committed their offenses before the abolishment of parole in 1995. This bill follows a JLARC study that was done, which cites Virginia having one of the most restrictive policies in the country for compassionate release, and it follows the recommendation of the JLARC study to move it from 3 months to 12 months. Main reason there, a 3-month window is very short. That diagnosis often is not precise enough to thread that needle. Unfortunately, while the applications are going through, prisoners will often die. I will say COVID has created another problem. If someone is already experiencing a terminal illness, they're compromised, their health is compromised. If they were to catch COVID, it would frankly make it almost an immediate death sentence and would create more difficulties. This bill is also consistent with the recently passed federal criminal justice reform in the 2018 First Step Act. With that, I'll be happy to answer any questions you have, Madam Chair, or any committee members.
Thank you, Senator Bell. We have 2 speakers. I would ask the clerk to allow Shannon Ellis to speak. Here we are. Welcome.
Good afternoon, Chairperson Favola and community members. My name is Shannon Ellis, and I'm an attorney with the Legal Aid Justice Center in Charlottesville, Virginia. I appreciate the opportunity to speak in support of this bill. We support this bill because it creates an important release mechanism that is missing from Virginia's current framework. Right now, appealing to the governor for medical clemency is the only way for a terminally ill person to be released. And the policy requires that person to have only 3 months left to live. This is one of the most restrictive policies in our country. And Virginia currently has no release mechanism for individuals who are seriously physically disabled. I spend most of my time working on issues around incarceration and working with incarcerated individuals directly. And I've met many people in the course of the work that I do who deserve and desperately need the relief this bill would offer. These are individuals who are so disabled or ill that there is no safety purpose served by incarcerating them. People who are bedbound or unable to walk or see, or those who have advanced dementia. Without the kind of release mechanism offered by this bill, they suffer inordinately and often die alone behind bars. Our society does not benefit from incarcerating these individuals, and we very much hope that you will pass this bill to open a meaningful path to their release. Thank you for your time.
Thank you for your remarks. We also have Camille Cooper. Senator Morrissey. Yes. You have the floor, Senator Morrissey.
Can you hear me now?
Yes.
Great. Ms. Ellis, are you with us?
Yes, sir.
All right. Ms. Ellis, I listened carefully to what you said, and you indicated that some of the people have 3 months or left to live. Some they can't see, they can't walk, and that society does not benefit from incarcerating them any longer. The patron of this bill said that every one of these individuals has less than 12 months to live. Can you tell me if you agree with that portion of the bill that excludes those people convicted of a Class 1 felony from benefiting from this legislation?
I would say that this bill is a huge step forward and would open a pathway to release for many, many people who need it. I personally am of the view that there is no category of people who should be carved out from the possibility of mercy. But I don't think that that detracts from the fact that this would be a major and much needed reform in our current policies.
Thank you, Madam Chair. Thank you, Ms. Ellis. She answered my question.
Thank you, Senator Morrissey. Let's go to our next speaker, Camille Cooper. Welcome.
Good afternoon, Madam Chair and honorable members of the committee. Thank you for allowing me to speak on 5018. Our only concern at RAIN, I am Vice President of Public Policy at RAIN, and our concern is that despite perceptions that older offenders or geriatric offenders are less dangerous, with regards to sex offending, that is not the case. Within the Virginia Department of Corrections, when I sat on McAuliffe's Parole Review Commission, the largest demographic of first-time offenders coming in were coming in over the age of 50 for sex offenses. So what we would appreciate is that sex offenses be excluded from the provisions of 5018 as it relates to geriatric. Thank you.
Thank you, Ms. Cooper.
Madam Chair?
Senator Morrissey?
Thank you, Madam Chair. I have a question of the witness. Is it Camille Booker?
Cooper.
Cooper, excuse me. Ms. Cooper,
yes.
Can you tell me why, if somebody is a sex offender, they should be excluded if they've got less than 3 months to live, if they're dying of cancer, if they're bedridden? Well, how does that possibly serve the Commonwealth to keep them incarcerated?
My comments are only specific to the 65, so little I and 2 little I of the bill, not the terminally ill. We're not opposed to compassionate release or for terminally ill.
All right, thank you for that. Thank you, Madam Chair.
Thank you, Ms. Cooper. Thank you, Senator Morrissey. Colleagues, the bill is before us. It does have to be re-referred to Finance. I'd like a motion.
Madam Chair?
Senator Boysko?
Move to refer to Finance.
Madam Chair, substitute motion.
I've got one motion on the floor. Is there a second to the motion to support this and re-refer to Finance? Is there a second? Second from Senator McPike. Okay. And Senator Morrissey, did you have a substitute to that motion?
Madam Chair, if it's appropriate, I have an amendment to SB 5018, and I'd like to make that motion now.
You have an amendment to the bill or an amendment to the motion?
Amendment to the bill, Madam Chair. And I'd like to speak to it.
Okay. Before we vote on the motion, you may offer an amendment.
Parliamentary inquiry. The motion on the floor is to pass.
That's correct.
There could be a substitute motion to pass by indefinitely, but it's not proper for a substitute motion to amend at this point.
Senator McDougall, is that correct? I will defer to staff. Is that? Okay, I will ask the maker and the seconder of the motion if they would withdraw the motion for the moment. Okay, motion's off the table. Senator Morrissey.
Thank you, Madam Chair. My motion is to delete the words on paragraph B, first line, the words other than a Class 1 felony, and I'd like to speak to that motion.
Okay, you may speak to the motion.
Thank you, Madam Chair. I would tell my colleagues that a Class 1, there's only one Class 1 felony, and that's capital murder. And what we're saying here, this bill is a bill of compassion, it's one of mercy, It suggests, as the patron said at the beginning, that somebody is dying. They are terminally ill. The patron said that they have less than 12 months to live. Ms. Ellis said they're talking about somebody with less than 3 months to live. They are bedridden. They are cancer-ridden. They are going to die. If this bill is what it purports to be, one of mercy and one of compassion, then it makes no sense to exclude or carve out an individual that has been convicted of a Class 1 felony. No sense whatsoever. If you believe in this bill, as I do, if you believe in the soul of this bill, as I do, then you would agree with me that there should not be a carve-out, and I'd ask you to join in my motion to strike the words other than a Class 1 felony.
Madam Chair.
Is there a second to your amendment? There's a second by Senator Boysko. Any
Chairman.
other discussion on this amendment?
Madam Chairman,
Senator Sorvell.
I have a question for council. Where's council? There he is. A question for council. So can you just confirm for me that the ambit of this proposed amendment is not just for those who are terminally ill, but it would also allow somebody who is convicted of capital murder who is permanently physically disabled to then petition for parole?
Shh. Mr. May, would you like to respond?
His mic is out. 1 second.
Madam Chair, Senator Serval, that's correct. It will also apply to just the original geriatric provisions that are already in that section. So you'll have not only that, but you'll have the terminally ill and physically disabled as well.
Madam Chair. Back here. Madam Chair, I appreciate the motion and the feelings of my friend, the gentleman from Richmond. I know we talked about this last year. I would ask you to defeat this motion for 2 reasons. One, we carved out Class 1 felons for a reason. This would be a giant step forward. I think including Class 1 felons would seriously jeopardize this bill, which didn't pass the House in the 2020 session. And I think it's important that we move forward with it. The second thing is there are some Class 1 felons, while all of this is at the discretion of the parole board, that I think still remain a danger. And frankly, I wouldn't want to open that door. I would argue, while I definitely have compassion for those who are dying, a Charles Manson would still be a danger to society. He could get other people to do things. So that's why I didn't include Class 1 felons. And while I definitely hear the passion of my friend, I still respectfully ask that you defeat this amendment.
Okay, the amendment is before us, was made and seconded. All those in favor of the amendment signify by saying aye. Aye. All those opposed signify by saying no.
No.
No. The chair believes that the amendment was defeated. Okay, the bill is okay. Motion has been made to report and re-refer to finance, and it has been seconded. My primary motion was Senator Mason, and secondary motion. Seconder was Senator McPike. All those in favor
Madam Chairman,
signify by saying aye.
do we get an opportunity to speak to the bill?
Yes, of course, Senator McDougall.
Thank you, Madam Chairman. Madam Chairman, I think we heard from some people in the community that spoke and talk about how dangerous this is. And I think we actually heard Senator Bell talk about how dangerous this bill could be. There's somebody who could be permanently disabled, but still able to physically go out and harm members of the community. This bill would allow rapists and child molesters to be released early when they could still be a danger to the community and our children. And Madam Chairman, I know we debated this at length during the regular session, but this bill is no better than it was during the regular session and still creates substantial danger to our community. So Madam Chairman, I'd ask the members to oppose the bill and continue to make our communities a little bit safer than what this bill would do.
Thank you, Senator McDougall. I will just note that the still decisions would be made by the parole board, who would have to promulgate regulations. Senator Morrissey? Was it Senator Morrissey who would?
Yes, Madam Chair. Madam Chair, I'm technologically challenged. Can I be heard? All right. First of all, we seem to go over this same point time and time again. My good friend from Hanover County suggests that the person is going to be granted parole. This bill, which I'm going to support, notwithstanding the amendment that I made, simply makes the person eligible for consideration. So here is what happens, folks. An individual who is dying, has 3 months or less to live, has cancer, is terminally ill, it now becomes eligible to be released. Two routes we can take. One route is send them home to their family so they can die with their family. The parole board can say, oh no, let's keep them in DOC, where we'll spend $100,000 or $150,000 a month to keep this person who only has 3 months to live alive. Remember, folks, you're not saying the person is going to be released by voting for this bill. You simply say they are eligible for parole. For those reasons, Madam Chair and my fellow colleagues, I'd ask that you support the bill.
Madam Chairman.
Madam Chairman. I will, Senator Cosgrove, Senator Kiggins, and then I would like to move towards a vote.
Thank you, Madam Chair. Thank you, Madam Chair. I hope my colleagues will actually look at this bill and see exactly what we're doing. We're going to let the parole board of the Commonwealth of Virginia make further decisions on releasing dangerous people into the community, as we've seen them do, and as was reported by the Inspector General. There's some serious problems with the parole board. There's some serious problems with this bill. We've heard about the person's going to die in a couple of months. Well, this bill does a lot more than that. If we have a geriatric prisoner who may have an irreversible knee condition, they are permanently disabled. And under the language of this bill, they can be considered for parole. Well, what's going on in this country right now? I don't think we can afford to release that type of people back into the general population of the Commonwealth. This bill is not well thought out, and I hope we'll defeat it.
Senator Kiggins.
Madam Chairman, just speaking to the bill, I know that people are living much longer into their 60s and 70s and beyond, so geriatric and stating age 60 is I think really middle age. And I don't have a problem with being compassionate towards hospice people or people who are terminally ill, especially as a geriatric healthcare provider, but the problem I have with this bill is the word "or" and the physical disability part. It doesn't specify what percentage of disability, and knowing that people with disabilities are capable of committing crimes. And then the other issue I have with the bill is what Senator Cosgrove had mentioned. Just, I'm not a lawyer, but I certainly know that the parole board has been on front page headlines in the recent news. So trusting them to make this determination for parole for even people that we're going to consider geriatric at the very young age of 60, in my opinion, I just can't support the bill because of that.
The motion is before us, and it is a motion to report and re-refer to finance. Will the clerk please call the roll?
Senator Hanger.
No.
Senator Locke. Senator McDougall.
No.
Senator Reeves. Senator Chafin. Senator Cosgrove?
No.
Senator Serval? Senator DeStaff? No. Senator McPike? Aye. Senator Spruill? Aye. Senator Mason? Aye. Senator Boysko? Aye. Senator Morrissey? Aye. Senator Kiggins?
No.
Senator Favola?
Aye.
8 ayes, 7 nays.
Thank you. Okay, colleagues, we are moving on to Senate Bill 5036. 5034 will be lively, and we're going to put that at the end. So 5036 has to do with the special events license. Our patron is Senator McPike. I don't see any speakers signed up, so I am going to ask Senator McPike to present the bill.
Thank you, Madam Chair and members of the committee. Senate Bill 5036, as the committee is familiar with, is associated with the special events license. 2 years ago, we passed the legislation allowing localities, nonprofits, and business improvement districts to have a designated ABC permitted area where you have multiple restaurants participating. Last year, Senator Vogel amended it to allow 16 days. What this bill does is specific to the condition we find ourselves with COVID and with a health emergency in place that reduces restaurant capacity. And so what this would do is eliminate the number of days while we're in a health order reducing restaurant capacity. I'm sure many of your localities like mine have many small businesses and restaurants that have been struggling. Many localities have adapted by including some curbside seating. However, the ABC license cannot extend sort of beyond the extended area where you have sort of joint areas, whether it be pavilions or pocket parks or other community assets that could be deployed to add additional table seating. And so the regulations, as well as the existing code that's already on the books, which would require the label of which the restaurant that the drink comes from, would still apply. So this is a very narrow measure that would only take effect during the health crisis. Additionally, it's incorporated comment from ABC and Travis Hill's team requiring that if a special event licensee has a permit, that they notify and update ABC that they're going to use this provision of unlimited number of days. So it still provides that localities under the existing code have to consult with the ABC, and so there's still full coordination. Additionally, they're responsible for the cost of policing as well as providing security for those areas. So with that, Madam Chair, I'm happy to address any questions from the committee.
Madam Chair.
Thank you, Senator McPike. Senator Cosgrove.
Thank you, Madam Chairman. Speaking to the bill, Senator McPike is one of the least, quote, liberal guys when it comes to ABC law. And I will tell you that I think this bill is a very good bill. It is especially well served to the areas where we represent, Virginia Beach and Norfolk, et cetera. You know, when the executive orders come out and say you can only have 50% capacity in your restaurant, this bill would offer an awful lot of help to those businesses to serve more patrons who want to be served and are being turned away because they can't get a table at a restaurant as it is now. So I hope we'll support this bill, and at the appropriate time, I'd move to report the bill.
Okay, a motion has been made and seconded. It does not have to be re-referred to finance, and all the stakeholders seem to be okay with the bill. So,
Thank you, Madam Chair.
do you move to?
I think there's
you
Senator
move
Cosgrove.
to report, and you
motion.
were the seconder.
I think McDougall.
Okay.
Seconded.
Senator McDougall was the seconder. Okay, on a motion of Senator Cosgrove, second by Senator McDougall, motion to report. I'll ask the clerk to call the roll.
Senator Hanger.
Aye.
Senator Locke. Senator McDougall. Senator Reeves. Senator Chafin. Senator Cosgrove. Senator Servo. Senator DeStaff. Senator McPike.
Aye.
Senator Spruill. Senator Mason. Senator Boysko.
Aye.
Senator Morrissey.
Aye.
Senator Kiggins.
Aye.
Senator Favola.
Aye.
Ayes 15, no zero.
Well, that was nice and collaborative. We are moving on now to the last bill on our docket for this meeting is Senate Bill 5034. Senator Boysko, this is your bill. It has to do with conditional release. It also has to do with earned sentence credits. According to my notes, you have an amendment. Is that correct? Is it a line amendment or an amendment in the nature of a substitute?
Madam Chair, it's line amendment, and I would ask our clerk to read it for us.
Okay.
Madam Chair, it's one line amendment. I did just offer it on LIS, so you can see the text of the amendment there. It's on line 29, after 4, strike the remainder of line 29, through Title 18.2 on line 30 and insert the following language. Romanet 1, a Class 1 felony, or Romanet 2, any of the following felony offenses where the victim was a minor, colon, A, rape in violation of Section 18.2-61, B, forcible sodomy in violation of 18.2-67.1, C, object sexual penetration in violation of Section 18.2-67.2, D, aggravated sexual battery in violation of Section 18.2-67.3, E, an attempt to commit a violation of Clause A, B, C, or D, or F, carnal knowledge in violation of Section 18.2-63, 64.1, or 64.2.
Okay, I'd like a motion to accept the amendment. Okay, motion has been made and seconded. All those in favor of the amendment signify by saying aye. Aye. Anybody opposed to the amendment? Okay. The bill as amended is before us. Senator Boysko, go ahead and make a presentation.
Thank you, Madam Chair. Today I present, excuse me? We just adopted the amendment by a voice vote. Madam Chair.
Is there a request for a voice vote? Colleagues, did you want a voice vote on the adoption of the amendment? Okay. I mean a recorded vote, is that? Okay, we weren't on the board, but I will ask the clerk for a roll call vote on the amendment.
Senator Hanger. Senator Locke. Senator McDougal.
No.
Senator Reeves.
This is on the amendment.
Senator Chafin.
You couldn't hear you.
This is on the amendment.
Senator Chafin. Senator Cosgrove.
No.
Senator Serval. Senator DeStaff. No. Senator McPike. No. Senator Spruill. Senator Mason. No. Senator Boysko. Senator Morrissey? Aye. Senator Kiggins?
No.
Senator Favola?
Aye.
7 ayes, 8 nays.
Okay, so your amendments, the bill's not amended. Senator Boysko, do you want to go forward?
Yes, ma'am. Thank you, Madam Chair and members of the Senate. SB 5034 is a bill to increase the amount of sentence credits earned by inmates for full participation in rehabilitation programs and good behavior. Further, this bill provides the same provisions that we just voted on with Senator Bell's bill for compassionate release of inmates who are terminally ill or permanently disabled and are no longer a threat to society, with the exception of those who are incarcerated with a Class 1 felony. As we have not been able to get the amendment, this bill will include a number of exceptions for who could earn sentence credits, and if you would like me to go through that, I will be happy to. It is, excuse me for fumbling through this, the code provisions of 19.2-297.1, which are violent felonies, and provisions in Article 4, 18.2, 362 felonies against children, basically. This bill is about hope and about change for generations who have been impacted by the existing system. We all have to realize that in Virginia, we have faced systemic racism. Our incarceration rate is much higher than the national average. We have a whopping 779 individuals per 100,000 Virginians, and there is clear evidence of substantial racial disparities. Also, I want to point out that we are spending more than $1 billion on the Corrections Department each year alone. And, it just brings me to, make sure that we realize over 50% of the people who are incarcerated are African Americans, and we wonder why there is racial disparity in our prisons. We wonder why our prisons are overcrowded and filled with people of color, and we wonder why sentences are so long. In the 1990s, there was a misguided attempt to reduce crime. The tough on crime laws were passed, but they weren't really even enforced fairly. Prosecutors in many areas historically chose to charge young men of color with higher numbers for more extreme charges for the same violent incidents, while white men may have always committed them and had a lesser charge. Often this has included charges stacking and the loose use of malicious wounding charges, among other things. And the judges and the juries did not sentence people equally for similar offense. Many of the people who are serving now have been in when they were very young, making serious mistakes when they were teenagers or very young adults, and they've been given sentences of 40, 60, 80 years. We know that people who are against this concept of earned sentence credit may claim that that goes easy on violent criminals and it might endanger the public. However, that's not what the evidence shows when we look at it around the nation. States with strong earned sentence credit programs have seen reduced recidivism. Research has shown that prolonged confinement is what further damages inmates, and it's counterproductive to the mission of rehabilitation and to a path of self-sufficiency once the individual re-enters the community. The factors that drive violent crime are shame, isolation, low socioeconomic status, and exposure to violence. And I want you to make no mistake, the overwhelming majority of the incarcerated will be coming home one day. Prisons without earned sentence credit offer no path to rehabilitation and redemption. They breed more violence, and they make us more endangered when they get out of prison. 34 other states offer higher earned sentence credits than Virginia does. And I'm from the Deep South. Alabama and Arkansas, and also Texas and Oklahoma, have higher earned sentence credits. States that have enacted earned sentence credit programs have also shown evidence of saving an average of $1.90 for every dollar spent, and that's from an NCSL report. It's imperative that we make the changes in the operations of our corrections facilities using methods that have been proven and data-driven policy to reform our prisons and jails. And it's time has come for our Commonwealth to focus on evidence-based rehabilitation rather than long incarceration. I believe, and I know that there are many people who do, believe that people deserve a second chance. Last night I was on a call with a group of people, of formerly incarcerated folks, and to hear their personal stories of how they learned early on that they had made a huge mistake and how they had been waiting to try to redeem themselves, and they are. They are holding jobs, they are buying houses, they are raising their children, they're doing good work. When we expand earned sentence credits, we are giving them an incentive to work hard, to build job skills, to treat substance abuse, to seek an education. We can release inmates who are bitter, who have no skills and feel hopeless, or we can do the right thing and treat people like human beings. Currently, the law allows for 4.5 days of credit for 30 days. This bill proposes an expanded system, gradually increasing from 13 days from 30 days served off an inmate's sentence in the first year, gradually through a 5-year span to 30 days of successful participation in educational vocational rehab programs. And again, this is building up to a 5-year ability to get that kind of earned credit. An earned sentence credit, as I have said, requires the inmate to participate fully and cooperate in all assigned rehab programs in order to receive that credit. And they don't have to absolutely be perfect, but they have to be pretty close to it. Earned sentence credits will provide the opportunity for incarcerated individuals to make things right for themselves as they work hard to earn the opportunity to return to their communities. I also want to remind the body that in this bill, it also includes the compassionate release measures that we just approved that were provided by Senator Bell's bill. It's a comprehensive bill on the release of prisoners. And you know, this is fiscally responsible if you look around the country, and I ask that you vote to send this to the Senate Finance for further consideration. Thank you very much. I have a couple of people who are on the call who are ready to speak and can answer questions of technical nature as well. Thank you for your time.
Thank you, Senator Boysko. We have 13 individuals who have indicated an interest to speak. Excuse me. I would ask our speakers if you could keep your remarks to 3 minutes. That would be extraordinarily helpful. We appreciate your interest in this topic. I'm going to go right on and call our speakers, and colleagues, if you have questions, feel free to ask them as the speakers are presenting. Jen Carter is our first speaker.
Hello, Madam Chair. Can you hear me?
Yes, we can hear you.
Wonderful.
You
Thank
may
Madam
want to
Chair.
speak a little louder. Maybe you can get closer to the microphone.
Okay. Thank you, Madam Chair, and all the speakers of the committee for allowing me to speak today. My name is Jen Carter, and I'm co-founder of the Humanization Project. We work to humanize people behind bars with the hope of driving criminal justice reform. And we worked during regular session with Delegate Don Scott on this bill and advocating for this bill. I come before you today as a white woman, but I want to talk to you about racial justice and its tie to the earned sentence credit expansion legislation. I grew up in Southwest Virginia. I have experienced white privilege all of my life, but I still remember when I was 2 years old in the sandbox on my first day of preschool and first witnessed people discriminating based on the color of someone's skin. It disturbed me then, and it still does to this day. I love this Commonwealth. It's my home and my namesake, but as Delegate Bagby, head of the Virginia Legislative Black Caucus, has recently said, if we are going to continue building a more inclusive and just Commonwealth, we must acknowledge and denounce the darkest parts of our nation's history. I hope and believe we are all seeing that now and working towards that as best we can. But make no mistake, Virginia is where racism originated in this country with slavery at the very beginning, and it continues today with our prison system. As the Humanization Project, we are in touch with people behind bars on a daily basis. At State Farm Enterprise Unit, guys work in the prison industrial shops that generate millions of dollars for private industry each year, yet they get paid only pennies an hour. Could you take care of yourself on $50 a month? And if they refuse to go to work, say for something like being terrified of contracting COVID-19 at a non-essential job, they can face getting more time on their sentence. If that doesn't sound like slavery, I don't know what is. In 2019, approximately 55% of people behind bars were Black, despite being only 19% of our state population. I think we can all agree that something is inherently wrong with those statistics. The earned sentence credit expansion legislation would give an opportunity for those who have bettered themselves and earned time off of their sentence. This is a chance to right the wrongs of racial disparity, but only if violent crimes are not excluded. Most people with nonviolent convictions in DOC are white, so only giving this opportunity to those with nonviolent offenses would further perpetuate the inequity already inherent in the system. I understand the knee-jerk reaction and emotional response to anecdotal incidences, creating the desire to eliminate certain crimes, but that is just simply succumbing to fear-mongering and is contrary to the evidence. We know that murder, manslaughter, and sex crimes have the lowest recidivism rates. Also, sentences match the crimes, and those who have done the worst, Class 1 felonies, get life sentences and are unable to earn time off anyway. Everyone else gets out at some point. Don't we want them to be better citizens when they do? So please pass the earned sentence credit expansion bill for all people behind bars. I believe right now this is one of the most anti-racist things we can do. Again, thank you, Madam Chair, and members of the committee for allowing me to speak today. I really look forward to seeing what all you are able to do for racial justice and criminal justice reform during special session. And I'd be happy to take any technical questions on this bill. If anybody has them, I'm happy to talk about any aspect of it.
Thank you, Ms. Carter. Next, we'll hear from Sean Juanita.
Good afternoon. Can you hear me?
Yes, welcome.
Thank you, Madam Chair, and thank you to the committee for allowing me to speak today. I'm here to speak in support of earned sentence credit expansion. My name is Sean Juanetta, and I'm the legislative liaison for the Humanization Project. I also served over 16 years in the Virginia Department of Corrections for a nonviolent property crime. In 2004, I was sentenced to 30 years in prison for embezzlement. During my time in prison, I worked hard towards reconciliation, restoration, and forgiveness. I also sought rehabilitation, and because of a few people who were willing to reach it down to give me a hand up, I worked to incorporate new pro-social behaviors and habits that were essential to my rehabilitation. Because of this, I earned the support of several members of this body in my petition for executive clemency. And in April of this year, Governor Northam granted my pardon, relieving me of over a decade of more incarceration in Virginia prisons. Expansion of earned sentence credits affords a similar opportunity to the tens of thousands of men and women incarcerated in Virginia. My restoration and rehabilitation began with a conscious decision to pursue a pardon, and my behavior followed. And at first it was difficult, but as time passed, it became easier, and soon I habituated these positive and desirable behaviors, and they eventually became incorporated into my character. Great strength of this bill is the progressive rewards it provides and the fact that it supercharges penalties if someone in prison steps out of line. This empowers Department of Corrections staff, which will improve morale and reduce the staffing issues that exist. It also provides a roadmap to redemption for thousands who will be returning to the neighborhoods of the Commonwealth. We all want these returning citizens to be successful and crime-free, given that 95% of the people behind bars are going to get out someday. It's better for everyone, and the best way to do this is to build better citizens while they're behind bars, rather than hoping that they'll figure it out upon release. SB 5034 provides a conduit for that character growth and turbocharges the incentive and motivation to do so. Finally, I'd like to add how important it is to include everyone in this bill. Excluding the large portion of the prison population that the current exclusions do, the cutouts manifest a number of issues ranging from increased racial inequality to increasingly dangerous prisons. And I can speak to this as someone who spent over 16 years in Virginia correctional facilities. This bill, as it's written, will establish a case-class system within the prisons, making it easy and even beneficial for people serving time for violent crimes to prey upon those who are serving sentences for non-violent crimes. The case system makes the prisons more dangerous for correctional officers and the other staff within and volunteers that come into the facilities. The exclusions further create a logistical nightmare for prison officials in classifying and safely housing the men and women in their charge. These exclusions do not enhance public safety, they in fact move the needle towards a more dangerous and treacherous prison system for everyone. I respectfully request that this body expand earned sentence credits to everyone incarcerated in Virginia, affording all those behind bars the same opportunities for success, redemption, and restoration that I have the extraordinary privilege to experience that enables me to appear before you today. Together, we'll experience a safer and more equitable Commonwealth that will impact generations to come. I welcome any questions that I can answer for anyone within the body. Thank you.
Thank you for spending some time with us. Next is Donald Keck.
All right, thank you, Madam Chair. Can you hear me?
We can't hear you clearly.
All right, I will try to speak up for you.
That's
any
better. Thank you,
All
Mr. Keck. That's better.
I appreciate the opportunity to let me speak today. I'd like to briefly talk to SB 5034 regarding incentivizing self-improvement. I'll start by saying that psychological research and criminal justice research shows unequivocally that the best way to improve public safety is to improve offenders while they are incarcerated. The best way to do this is by promoting their education, their economic and work opportunities, and continued community engagement. This bill offers meaningful, tangible incentives to return to society as a better and more capable person. One thing that my experience as a psychologist in the correctional system has shown me is that any behavior that is rewarded, you will get more of. Any behavior. The greater the reward, the more of the behavior you'll get. This legislation actively and explicitly offers offenders the opportunity to earn enhanced good time and provides increasing rewards for maintaining a top-level commitment to self-improvement. Now, this is not a handout. I do not endorse giving good time up front and taking it as you go. I believe that offenders need to start with no good time and earn their way up to a high level. To earn at the highest level in this bill, one must work productively, educate themselves prolifically, and remain infraction-free for 5 consecutive years. Now, that's not an easy feat, considering that prison is a highly provocative environment. Positive and progressive incentivization, such as in this bill, definitively improves public safety for everyone, as we know that 95% of the people behind bars now will eventually return to the community, whether or not they are rehabilitated. Let's return our people to the communities as better citizens. Last point I would like to make is, in considering Senate Bill 5034 as a 30-year veteran of the Department of Corrections as a psychologist, I am in favor of striking Part A of this bill, and I fully endorse Part B in total. I am open to any questions anybody may have, and I appreciate your time.
Thank you, Mr. Keck. Joanna Gussman had indicated she wanted to speak. We're not sure she's still in the chat room. Okay, I don't think she is. Let's move on to John Peterson. And I do want to note that some folks had wanted to comment through our chat room on this bill and had either attempted to sign in too late or there were technical problems. We welcome your comments just the same, and we encourage you to write your comments through email, and the email address would be committee operations, all spelled out, one word, committee operations @senate.virginia spelled out .gov. Thank you. Mr. Peterson, your time will be restored.
Thank you for this opportunity to speak.
Sure.
I'm testifying on behalf of Senate Bill 5034. During and after the crime wave of the 70s and 80s, we got serious about locking people up for long periods of time, including cutting good time earned way back. There's no evidence that this really helped reduce violence as a whole. In fact, Mark Earley, who led the charge to eliminate parole in the 1990s, has said we were wrong. As a result, we have one of the highest incarceration rates in the world, worse than Russia or China or just about any other third world country. There are books written by professors who've spent decades studying the relationship between prisons and crime. They show that some states have already released some prisoners early, including prisoners in for crimes classed as violent. These states have generally experienced a drop in violent crimes at the same time as these prisoners were released. For example, between 2010 and 2014, state prison populations dropped by 4%, while crime rates declined by 10%. During approximately the same period, the number of people in prisons for violent crimes declined by 20,000. So we let all these prisoners out, and yet crime actually dropped, both violent crime and property crime. 5034 requires, for the first time, that prisoners participate in rehabilitation and education classes in order to be released earlier. The present regime does not do that. These prisoners are precisely the ones who have low recidivism rates. They've been reforming themselves. The prisoners who are serious about making restitution, apologizing to victims, and getting their lives on track to stay sober and legal, they are the ones who will get released earlier. The ones who are not interested in these will get no benefit. Don't restrict the good time to nonviolent offenders. Study after study shows that people age out of violence. The 40-year-old being released is not the same person as the impulsive and hot-headed 20-year-old who committed the crime. Lots of people convicted of crimes classified as violent have taken the classes on restitution, the impact of crime on their victims, and staying sober. They have looked at themselves in the mirror and decided to become different. They are ready to take their place in society as tax-paying, law-abiding citizens. Thank you for this chance to talk.
Thank you, Mr. Peterson. Next on our list is Ben Knotts. Is Mr. Knotts still with us?
Madam Chair, thank you for hearing me. Can you hear me okay?
Yes, we can. Thank you.
I'm Benjamin Knotts. I'm the legislative liaison with Americans for Prosperity in Virginia. We support Senate Bill 5034. We've stood along many members of this committee advocating for smaller, efficient, and better government, whether it's tax policy or licensing policy. We've consistently advocated for breaking barriers that reduce the burden of government, ensure equality under the law, and allows every person to pursue their version of happiness. I hope then that we can drop some of the political posturing and focus on whether the status quo of our justice system is achieving better outcomes for Virginians who broke the law. They own their failures, and they don't merely want to serve their time, but they want to serve their time in a way that proves they're contributing citizens. Unfortunately, the status quo of our justice system does not differentiate between someone who serves their time with honor versus someone who serves their time with resentment. The status quo needs to be rejected. It needs to be improved, because it treats a person serving time who is humble, regretful, and cooperative with correctional officers the same as someone who is uncooperative, filled with animosity, and hostile to correctional officers. This is not good policy, and it needs to change. Time served does not produce a reformed criminal. Whether it's 5, 10, or 20 years, time alone does not change someone's attitude. They have to make a choice to change. And our justice system needs this reform in order to give these incarcerated Virginians one more reason to make positive choices. Earn credit for early release encourages incarcerated Virginians to develop a pattern of positive choices before they are released, so that they have been conditioned to do so after their release. And finally, it creates a better environment for correctional officers who are interacting and working in that environment. And finally, one more point. We're suffering this pandemic's impact on our economy and budget. And so when every single penny matters, why should taxpayers be spending money on incarcerated Virginians who have served time, proven they are ready to be a productive member in society, and they want to earn the trust of their community? 75% of Virginians believe we should scale back the excessive spending on our penal system, and the modest reforms here would save Virginia's budget by one projection, $30 million over the next 5 years. And upon release, these individuals will be buying meals. They're going to be buying groceries. They're going to be going to restaurants, and they're going to contribute to their local economies, adding to the tax reservoir, not being a draw on it. So why spend hard-earned tax dollars continuing to imprison Virginians who aren't dangerous to society, and we have the data to prove it? And finally, states across the political spectrum have passed this very reform, from Texas to New Jersey. President Trump, when he signed the First Step Act, embraced this very reform. So this is a nonpartisan issue, and we hope that this committee will pass it with a bipartisan majority. Thank you so much.
Thank you, Mr. Knotts. Next on our list is Francis Ross.
Can you hear me?
Yes, we can.
Okay. Hi, thank you for having me. I'm sorry I was caught a little off guard. I didn't know that my cue was on, but thank you for taking the time and trying to include everybody. I just want to let you know that I think that this bill is really, really important, but I think it's more important for it to include everyone. And I just want anybody who's watching from the public to understand that it needs to include everyone because they've already been charged for whatever crime it was that they committed. And we want to encourage everyone behind our prison walls to make the right choices, to better themselves, to improve themselves. And again, this bill really, really needs to include everyone who earns the right to be included in this. I just, once they're behind those walls, they should all be the same. And we shouldn't be subdividing them into different categories. I really just want to say that to restore hope to the people on both sides of those walls, that it's very, very important that this bill be amended to include all. And if this was open to the public, the room would be filled and there would be hundreds, thousands of people there saying that, again, this should be for everyone behind those walls who earns it. Thank you so much for letting me be part of this. And again, I think it should be for everyone.
Thank you, Ms. Ross. Appreciate your comments. Next on our list is Brian Kennedy. I'm not sure if he's still in the queue. He's not in the queue. Okay, we will go to Michelle Hawkins.
Hello? Can anybody hear me? No?
We can hear you.
Oh, you can. I can hear you now. Sorry about that. Hi, thank you for having me. This bill is amazing. We really, really need this, but it has to include some violent prisoners. You've got to look at a person rather than a crime. Not everybody that has committed a violent crime is actually a violent person. I'm currently working with 2 prisoners, but one of them is more powerful than the other. And he's a great example to show you that not all prisoners are, just because he's committed a violent crime. This is a young boy that was sexually abused for most of his life throughout his childhood. When he got to the age of 16, the abuse was continuing and continuing and continuing until one night his abuser went one step further. This young 16-year-old boy snapped and he ended up killing the person that had been abusing him his entire childhood. He's now 35 years old and he spent 17 years in prison. He had his childhood stolen because of sexual abuse and he's had his adulthood stolen because of that. I mean, come on, this person really is not a violent person. He really isn't. He is the sweetest boy. He was an honest student. His parents were in the military, but he was just a young boy that was sexually abused and had his childhood taken away from him. To exclude all violent offenders from this bill is just wrong. It's just really wrong. Another person that I'm involved with, that again I've been working with for 2 years, he was approached one night by with somebody with a knife. This guy was stronger than the other person. He's tried to protect himself and he ended up stabbing this person in the neck. This person is a psychologist. He's a brilliant man. He's very educated and works as a psychologist. It was an altercation one night that went wrong. He has now been in prison for 12 years. During the 12 years, he's been through all the hard prisons, your Greensvilles and your River North, and he put his psychology degree to good use and he helped a number of prisoners adjust to prison life successfully, become drug-free. He initiated exercises and workout plans, and he was actually a mentor in the education department. And because of his encouragement and his knowledge and his persona, he was a mentor in the re-entry plan in Greensville Prison, which is one of the notorious prisons within Virginia. And he helps people rehabilitate. He's now in a level 2 prison and he's doing really, really well. But this is just 2 people. You can't look at a violent crime and just say that they're all violent people, that they're a complete danger. This is just 2 examples that I've got that I know personally. There's going to be many more like these 2 guys in them prisons. And if they haven't, they've rehabilitated themselves with no incentive. The statistics prove within the prisons that the people with violent crimes get longer sentences. Therefore, all the programs that are available to help them rehabilitate, they're not really offered to these people because they've got so long to do. And because the prisons are so crowded, they have to wait. So the only way that they can get on these programs is to sort of sneak in where there's a gap. And they take them all on a voluntary basis and they do it themselves. There's not much else I can say on this, I'm sorry, but I do thank you for listening to me.
Thank you, Ms. Hawkins. Next, it's Kayla Cotton.
Hello.
Good afternoon.
Good afternoon. Thank you for having me today. My name is Kayla Cotton, and I am a member of the RAIN Speakers Bureau. I first want to state that I support this bill as a whole, but I do think that there should be a carving out. And let me state why. I want to ask you a question. Have you ever looked into the eyes of someone truly evil? Have you ever had someone who lacks empathy and cares not how they may hurt you in order to get what they want? I have. That man is a white Christian middle-class boy named Joshua Caudell. His eyes had no soul as he raped me while I lay medically incapacitated. My screams were so loud that my roommates were woken by them and they were able to save me. On August 20th, 2019, Joshua Caudell pled guilty to 1 count of rape. He was sentenced to 20 years, 12 and a half suspended. In addition, he has now had more accusations come forward. He has been indicted on another count of rape. If this bill passes without being amended, he will be eligible for a release in 2021. This man does not have any remorse. I tried to go and meet with him to show him that I forgave him, and he wanted nothing to do with me because he stated I did nothing wrong. If he gets out, he will rape more women. If he gets out, he will come after me for speaking out against him. Today, I ask that you make a statement. I ask that you show us survivors that our safety, that our voices are important. Thank you.
Thank you, Ms. Cotton. Thank you for sharing your story. Rebecca Courtwright, if you're still in the chat room, it's your turn.
Madam Chair, I have a question for council.
Yes, is that Senator McPike? Oh, I'm sorry, Senator Reeves.
And my question for council is, under this bill, would it include the code sections, just so I understand what we're doing here, 18.2-346B, solicitation of a minor under age of 16 for commercialization of sexual exploitation of a minor for sex, 18.2-357.1, and then making of child porn, those folks that do that stuff to these young minds, 18.2-374.1. Would it include all those?
I will ask David May to answer that.
Madam Chair, Senator Reeves. So I didn't catch each one of them. I was trying to go through them as you were listing them out. If you click on Article 4, basically any crime that qualifies as listed as a felony within that article is going to be hit here. So I know it was hitting some of the ones that you just mentioned for sure. I just didn't get the entire list.
Thank you, council.
Thank you. So is Rebecca Courtwright in the chat room? No.
Yes, can you hear?
Did
Can
we-
you hear me now?
Okay. Sorry for the technical glitch. Go ahead, Ms. Courtwright.
Thank you. Today, you will hear from many people today calling for prison reform. Yes, changes need to be made, but I urge you to amend the bill to exempt sex offenders from time off for good behavior and early release due to age. I used to think the worst day of my life was when I was raped, but it wasn't. I thought the worst day of my life was when my rapist was released from jail, but it wasn't. The absolute worst day of my life was hearing that he raped again, and this happened multiple times. He created a new victim. Our justice system failed to keep the public safe. Even though I testified at great physical and mental expense to keep him in prison, he was still able to reoffend. We must send the message that perpetrators of sexual violence will serve their sentences. Fewer than 5 out of 1,000 perpetrators of sexual violence even go to jail. Many sexual offenders, like my rapist, are serial offenders. Send the message to sexual violent criminals and victims. Virginia takes these crimes seriously and will not grant time off for good behavior or early release due to age. Thank you.
Thank you, Ms. Courtwright, and thank you for sharing your story. Okay, we have Robert Buswell, and our last speaker is Camille Cooper. Is Robert Buswell still in the chat room?
Madam Chair.
I'm going to go to our next speaker, but Senator Servo, do you have a question?
Yeah, while we're doing that, can I ask council a question?
Yes. What is your question?
Council, following up on the question by Senator Reeves, he was asking about the Article 4 language on line 29 and 30, and I just want to confirm that if we don't change the law at all, the people in Article 4 of Chapter 8 of Title 18.2 currently get 4.5 sentence credits for every 30 days they serve. And so I think that language just preserves the status quo for those people is all it does. Is that correct?
Madam Chair, Senator Servo, that's correct for that category of inmates.
Okay, thank you.
Yep, thank you so much. Okay, it looks like Robert Buswell is not in. Oh.
I'm here.
Okay, very good. You've got 3 minutes. Welcome.
Okay. Well, thank you very much. I got dumped out of the queue and then I logged in real quick. I heard you call my name and I tried to get back as fast as possible. So thank you, Madam Chair, and the senators on the committee. I'm going to read from my paper. I know the people reading from their screen, but I don't do as well that way. My name is Rob Buswell. I'm from Sterling, Virginia. I live in the 33rd District. I believe my patron is patroning this bill. And I just want to say that I oppose this bill, SB 5034. I was a victim of child abuse as a 6-year-old. I am now 48 years old, and I've served 42 years of my life sentence. It never ends. He's in my dreams, and he walks with me every day as I watch over my children and your children if you're near me. I was given no grace and no mercy from my perp. My perp would meet the requirements that I've read in this bill. It was said of him in court as they wheeled him in his wheelchair that he was no longer a threat due to his age and his handicap. Sorry. He was given the grace and allowed to plead to one count, and the other count was dropped. That is 50% grace already. I know that there are a lot of plea bargains and everything that go behind the scenes that give these perpetrators grace already, but we're not given any grace or mercy. They suspended all the jail time. That was more grace. And what did he do with that grace? What did the perp do? 3 years into his suspended sentence, he admitted on polygraph, because that was part of the conviction in the case, to generating over 50 more victims. That was by the Virginia Department of Corrections, Probation and Parole. It's on public record. This bill is not about justice. Justice was doled out at sentencing. This bill is about grace. And remember who deserves that grace. Don't dismiss me as biased. I hope you don't. I carry a life sentence every day, just like all victims like me, like those ladies that spoke earlier. I'm making my plea to you. Remember, the perps had their time to make a plea. Give us victims grace, and grace to know that our perp will at least serve the minimum sentence that we were able to obtain. And just remember, this is one that always stuck with me after the Stanford victim. The Vice President Biden at the time said, remember, he was so proud of the victims for stealing their spines and coming forward and doing all these things. He knew it was hard. And I felt that because I had already been through the process by that point. And I really appreciated what he said. And he said that a lot of people have failed them. And I'm just telling you right now, the bills like these, I think, but the former vice president would say, this is a bill that would have failed people like me and like those other ladies that spoke. Well, I assume that this bill was written with good intentions. I think we all wish for the best in people. And it gives us warm and fuzzies to think that other people can rehabilitate themselves and some people can. I'm not saying that there aren't. But the fact is, with bills like these are not warm and fuzzy. They're ice cold and hard to people like me and those other ladies that spoke earlier. And I'm asking you to vote no. And I heard earlier, as the patron of the bill said, everyone deserves a second chance. And I will ask you a second chance to do what? Like the other lady said, create more victims, rape other people. I know that my person has created other victims. And I'm just asking you all, please, to vote no. Thank you.
Thank you, Mr. Buswell. Camille Cooper is the last person on our list, and after Camille speaks, I will remind folks that they can contact us through email, and I will give the email address. Maybe we can post it. Is Camille still in the chat box?
Yes, I'm here.
Great, welcome.
Thank you. Again, my name is Camille Cooper. I am Vice President of Public Policy. I'm going to start off with talking about the 3 studies that I included in an email to the clerk, hoping that I think she did disseminate it to everyone. So you have the full studies and you have the summary of the studies that I included in the email. 3 studies I want to talk about serial offending. In the first study by Rebecca Campbell, they studied 7,287 rape kit cases that were included in CODIS, the FBI's DNA database. And then they looked at those cases' criminal histories. In that study, roughly 40% of the offenders were serial offenders with between 2 and 15 victims each. In the Butner Redux study, they studied 155 incarcerated offenders at Butner Federal Prison. Between 155 offenders, there were 1,777 victims between them, both adult and child victims, which I'll get to in a moment. The Burke Tactical Polygraph study studied 127 offenders. Of those that had multiple contact offenses, 72 of those offenders had 282 victims between them. So I want to dispel this myth about recidivism. Recidivism does not measure reoffending, it measures rearrest. And so it doesn't tell you who's likely to reoffend, it tells you who's the most likely to get caught. And I want to be really clear about that. There's some other myths that were propagated earlier in testimony that I want to go over. One, the average age of sex offenders coming in for a first offense is 50 years old. You can look at the federal data, that's what it says. Out of every 1,000 rapes, 4.6 actually end up incarcerated. Very low incarceration rate. And why? Because most of these offenders are very savvy, they're charming, they're very nice, they get along with everybody. People will tell you when they're neighbors of an offender that gets caught, how nice he was, how they let their children go over and play at his house, because that's how much they trusted him. Sex offenders are impeccably capable of being able to groom adults and children, and they are able to reduce people's guard, and they are able to establish trust with victims And that's how they're able to offend. So if they
Madam
have
Chair.
good behavior in prison, it's because that same behavior is consistent with how they act in the outside world and those qualities
Chair.
and behaviors that they use to cultivate victims. I also want to make it really clear that there's a very high crossover between adult offending and child offending. There's a big crossover there. It's not about age preference, it's about opportunity. So the same people that rape a 5-year-old may have an opportunity to rape your grandmother when she's 75 and in a nursing home. They don't care. It's more about opportunity. It's about the offending. It's not about an age preference. So to limit any amendment to just offenses against minors is going to leave the majority of rape victims out in the cold. So I would ask that any amendment that's put forward to exclude sex offenders from good behavior credits and geriatric early release include all offenses, both against adults and minors. Thank you.
Thank you, Ms. Cooper. Senator Serville.
Madam Chair, I have a question for council. Mr. May, with regard to all the crimes we just heard listed off by the witness, rape and the sex crimes and all that stuff, isn't it correct that the bill is currently drafted excludes all of those crimes from the application of these enhanced earned sentence credits that we're about to vote on?
Madam Chair, Senator Serville, so again, I don't have the complete list of all the crimes that she mentioned. I did go through and identify some of the main crimes that appear in Article 4 if you wanted me to go through which ones fall underneath the exclusion.
Madam Chair, further question?
Senator Serville.
Rape would be excluded from the enhanced credits, is that right?
As we have it listed.
Madam Chair, Senator Serville, it's not coming up in the Article 4 provisions that we have there. What can be found in Article 4 are the family offenses and the crimes against children, unless it's...
Madam Chair, further question?
Let's get an answer to this one first.
Well, I'm trying to focus them a bit.
Is this a conversation? Okay, Senator Serville.
Council, wouldn't it be included in the 19.2, 297.1 list?
So I'm pulling that up 1 second.
I just pulled that.
Madam Chair? Madam Chair, would it not be
Senator Boysko.
except otherwise provided in 18.2-67.5:2 or 18.2-67.5-3 criminal sexual assault punishable as a felony under Article 7, 18.2-61? Would that not include rape? My understanding is with this, in the version that we have it, violent crimes, which I believe rape is a violent crime, would be excluded from earning the additional earned credit sentences.
Right.
And that we wrote it that way, particularly to make sure that we were addressing nonviolent, to reward the nonviolent felons in this version of the bill.
That looks to be the way it's written. We will wait for confirmation from General Counsel, but I did check the code.
Madam Chair, Senator Serville, yeah, I did pull that section up. So the offenses that are going to qualify under as an act of violence under 19.2-297.1A would be first and second degree murder and voluntary manslaughter under Article 1, mob-related felonies under Article 2, kidnapping or abduction under Article 3, malicious, felonious assault or malicious bodily wounding under Article 4, robbery under 18.2-58, and carjacking under 18.2-58.1, and except as provided in criminal sexual assault punishable as a felony under Article 7 or arson in violation of 18.277. And then conspiracy to commit this.
Colleagues, this looks like it's, if you there was an email sent that I believe had that option 3 listed. That's what it is. Okay. Thank you, Mr. May. Again, I'll just make a quick announcement on how to contact the committee for those who may have wanted to speak, but we suffered some technological glitches. The committee is very interested in your views. Please contact us through email. The address is committee operations, all one word, committee operations @senate.virginia, spelled out, .gov. Thank you to those who chose to participate in this discussion. Colleagues, the discussion is now with the committee.
Madam Chair,
Senator Reeves.
speaking to the bill.
Yes.
Madam Chair, I would just like to speak to the bill on behalf of victims that are out there, and I would also state to my colleagues that 18.2.346 is still within that and it's not in Article 4. So folks who exploit children for prostitution purposes would be able to earn good time credits. And I know my good friend from Harrisonburg had worked on human trafficking. And I think we've made a lot of progress there, and I think this would be a step backwards. And I think we heard from 2 victims today that are still going through troubles and tribulations, and that if we put any hope in the parole board, that's false hope because we've seen what they've done. So I'm going to throw up a no vote, and I would ask my colleagues to do the same.
Madam Chair.
Let me ask the patron to respond. Senator Boysko.
Madam Chair, thank you so much. I'd like to make sure that you saw that we also are including the Chapter 8 Crimes Against Morals and Decency, Article 4 Family Offenses, which includes sexual incest, prostitution, abuse and neglect of incapacitated adults, crimes against children, any indecent liberties with children, a felony 18.2-370, which includes the things that my colleague just mentioned. My understanding is that this bill, as written, excludes violent felonies and crimes against children of a sexual nature. This is a bill that will help give people who are trying to work to make themselves better, who are going to get out of jail at some point, give them the path to redemption. And you've had the opportunity to hear from a number of people today. I know that there's a lot of passion around this, but I believe it's the right thing to do. There is evidence around the country that shows that recidivism goes down with this kind of a program. Over 34 other states are using this same method in greater amounts than Virginia. And I hope that my colleagues will vote for it. And I'd like to point out again for my friends on the other side of the aisle, Americans for Prosperity support this bill. They believe that this is the right thing to do. And they're absolutely not liberal, bleeding heart folks like some of us. So I ask you to support the bill.
Thank you, Senator Boysko. Are there any other comments by committee members?
Madam Chair.
Any questions? Who's behind me? Senator Morrissey.
Thank you, Madam Chair. I mentioned in an earlier bill that we discussed compassion and mercy, and so I want to preface my comments by saying, listening to those victims today, we have great empathy for them, and we also extend any and all mercy and compassion to them and for what they've gone through, and we don't discount what they went through. But let me be clear about the following. At first blush, I think some of my colleagues on the opposite side might say this is just another piece of legislation with a liberal agenda to release and then fill in the nouns, the murderers, the rapists, et cetera, out into the streets. And that's an easy thing to say, but that is not what this bill does. If you look at the code sections, this bill is excluding people that have been convicted of murder, kidnapping, malicious wounding, robbery, sexual assault from earned sentence credits. What it does is the following. It shows that there's a nexus between earned sentence credits and reduced recidivism. There is evidence-based proof that people are rehabilitated. But the most important thing is the following. If you believe that we want to incentivize DOC inmates to be more productive, to be more purposeful, to be more law-abiding in their daily doings while incarcerated, then you would vote for this bill because it incentivizes them to behave whilst incarcerated. I would urge my colleagues to support this bill as it's currently written.
Any other comments on the bill, colleagues? This bill will be re-referred to Finance, so there will be another opportunity for discussion. If it is the wish of the committee to pass this bill and re-refer it to Finance,
Madam Chair.
I would welcome a motion.
Madam Chair, just to speak to the bill briefly.
Senator McPike.
Thank you, Madam Chair. Appreciate also the victim testimony as well. I think there are a couple of different things that as this bill, if it's to move forward to the committee, I think need a little bit further detail and consideration, certainly which is the different levels of time earned. I think also cross-referencing and ensuring the various code sections are excluded that I think the committee has been concerned of, meaning any other cross-reference code sections in regards to rape, child pornography, other serious violent offenses. Frankly, I don't believe that they should be getting additional credit. I know some speakers were very much in favor of it, but I would encourage the patron as this bill moves forward to consider the various frameworks ensuring that this bill is tightened up and also looking at the various levels of credit given that may cause others concern. So I think for furthering to this discussion, I'll move that the bill be passed and re-referred to Finance and Appropriations.
And motion has been made by Senator McPike and seconded by Senator Mason. I do think that we have to get probably some more clarification in certain areas. There is a separate bill going through the House of Delegates, as I understand it. The concept here is of value. Certainly, there have been studies that demonstrate that this credit sentencing can be a very helpful and effective tool in incentivizing folks to make good choices, as the speaker said, and also altering behavior. I guess we have to remember at the end of the day, 95% of those who are jailed are released into our society. So we have to use as many tools as possible to ensure that once they are released, they become productive and law-abiding members of our society and they don't return to jail. And I try to view the context of this bill and other bills in the area of criminal justice reform along that measure. I appreciate the comments that have been made, and I certainly appreciate the interest of our speakers, and I do not in any way want to minimize the impact on survivors. So we feel your pain, and thank you to those of you who came and shared your personal stories. Okay, a motion is before us.
Madam Chairman.
And it's been seconded. I'm going to ask for a roll call vote. Any other comments? Excuse me, Senator Cosgrove.
Thank you, Madam Chairman, ladies and gentlemen of the committee. Here we go again. We hear about the evidence shows, the studies show. We haven't seen the studies. We haven't seen the evidence. It's all anecdotal as far as we're all concerned. We are letting violent predators have more time away from their sentences. The juries or the judge gave them these sentences because they wanted them to serve a specific amount of time. And what we're doing as a legislator with this bill is changing the outcome of the sentencing that was provided by the judicial system. We are going down a terribly, terribly slippery slope with this type of legislation, the others that we've been passing, and others that are yet to come. We say, oh, victims, we're so sorry, we empathize with you. We feel your pain. I'm sorry, It doesn't seem like we feel their pain so much. I hope that this bill will not pass. We are being way too lenient and interfering in a separate branch of government as far as I'm concerned. Thank you, Madam Chairman.
Thank you, Senator Cosgrove. I will just note that there is information about rather extensive regulatory process that would have to be in place if a bill such as this were to pass. An inmate would be reevaluated regularly. There'd be expectations on educational requirements and other things, but I do understand your comment.
Madam Chair?
Senator Boysko.
I just want to clarify that the system is very well laid out in this bill, the levels, and if you go into the operations manual at the Department of Corrections, it clearly shows what qualifies for a level 1, level 2, level 3, level 4, and what a person has to achieve to be in it. Also, if any of my colleagues would like copies of the studies that I have, I'd be happy to share them with them. And again, I want to say again, this version of the bill excludes violent criminals. I don't know how much more clearly I can say that. This excludes violent felonies. They will not be eligible to take advantage of an increased earned sentence credit in this bill. They will stay where they are. And again, we've heard this before, most people who are in jail will be coming home at some point. This is an incentive to give them the skills so that they are ready to return to society. I feel terrible for everyone who's had a crime against them. This is not a bill to say that they were wrong or right. This is just saying we need to try to do a better system because what we're doing right now is not working. And I hope that my colleagues will support the bill, and if there's any other questions, we're happy to take them.
Okay, again, a motion has been made and seconded. I'm going to ask the clerk to call the roll.
Senator Hanger.
No.
Senator Locke. Senator McDougal.
No.
Senator Reeves. No. Senator Chafin.
No.
Senator Cosgrove. No. Senator Serville. Aye. Senator DeStaff.
Absolutely not.
Senator McPike. Senator Spruill. Aye. Senator Mason.
We'll amend it.
Senator Boysko. Aye. Senator Morrissey.
Aye.
Senator Kiggins.
No.
Senator Favola.
Aye.
8 ayes, 7 nays.
Okay, I will ask our clerk, is there anything more to come, any other business to come before Rehab and Social Services this afternoon? We have completed our docket for this afternoon. There will be another meeting. More bills have been referred to our committee, so we will be back in touch with all of you. I'd like a motion to adjourn. Okay, motion has been made, and I'm sure it's been seconded by quite a choir of people. Senator DeStaff seconded the motion. All those in favor, you may rise. Thank you. Committee's concluded.